Hello, everyone, and today is Monday, April the 20th, 2026, and you have joined Ask a Care Navigator, Mondays with Maureen. Hi, everyone. My name is Maureen Williams, and I'm the Director of Care Navigation here at Four Seasons, the care you trust, and we try to create this space on most Mondays to talk about issues associated with living well and aging well, and perhaps how Four Seasons may be of service. If you have any questions or comments, you can drop them into the comments box from whichever platform you're viewing, or you can call us at 866 466 9734, or even better, go to our website, which is fourseasonscare.org, and please spell out the number 4. And I'm joining you today from the Winkle Law firm, and I have to express my gratitude over and over again about how grateful we are that Winkle Law is serving as the title sponsor for this program, Ask a Care Navigator, Mondays with Maureen. Winkle Law Firm is one of the most well-established and well-respected law firms in North Carolina, providing exceptional legal representation to individuals, families, and companies in matters of personal law, business law, commercial law, and in particular estate planning matters with which I interface with the lawyers in particular. If you have any questions or you want to schedule a consultation, please go to the website. It really is very easy to navigate, and that is www.bwlawfirm.com. And I'm joined today by one of my special guests, my special friends to Four Seasons, Koral Alman. Tell us a little bit about yourself.
I'm an estate planning attorney with the Winkle Law firm, and I specialize primarily in estate planning on the front end, so helping families and individuals plan for their future and make sure they have the documents in place for that time. And then I also help families on the back end after they've lost a loved one with navigating the probate process or the trust administration process.
So helpful. And Koral is just a wonderful friend to Four Seasons. Yes. She also happens to be on our board. Thank you.
Yes.
She's a volunteer. And she and I love to do this session once a year around healthcare decisions, National Healthcare Decisions Day, which was April 16th, but it's still important.
Close enough.
It's always a good time to consider your healthcare decisions. So I'm going to just say, Laurel, take it away. Koral.
That's all right.
Take it away and tell us about advanced directives. You have a wonderful way of remembering them.
So there's many documents that we use. I always do my hand, as Maureen knows, for the documents that are designed to take care of you while you're alive versus the document, the last will and testament, that takes care of things when you've passed. So the 4 documents that help us while we're alive are a living will or advanced directive, a healthcare power of attorney, a HIPAA authorization, and then a durable power of attorney, which is more like financial or non-healthcare adult decision-making, paying your bills, filing taxes, all of that sort of stuff. And I'll bang through those real quick so that we can talk a little bit more about them. So a living will or advanced directive in that context is really end-of-life decision-making. It presumes that you do not want to be kept alive artificially by machination of any sort, and it gives guidance to your healthcare provider or a healthcare agent about when and under what circumstances you would like to be taken off of life-prolonging measures. It also gives guidance about whether or not you would like to receive artificial hydration or artificial nutrition. Then you've got a healthcare power of attorney that is appointing the actual person who would be carrying out that, but also any other healthcare related decisions that you're unable to communicate because you're incapacitated, you no longer understand, you're in a coma, or even if you're in surgery, but they need to make a decision while you're under sedation and they can't wake you up, get your consent, put you back. They will sometimes come to your healthcare agent under your healthcare power of attorney. That healthcare power of attorney also gives broad authority to your healthcare agent unless you wish to limit it. You could limit it in terms of, I don't want to receive psychotropic drugs, or I don't want electroconvulsive therapy, or for religious reasons, I don't believe in blood transfusions. Any sort of limitations that you want to give your agent. If you give no limitation, they have the same degree of decision-making authority that you have, which is you can consent or withhold consent for any treatment for any reason or no reason at all. They do have a fiduciary obligation to take care of you, but they have an extremely broad authority.
Right.
It also allows for clear legal authorization for organ donation or donation for medical study. Your driver's license is an indicator, but someone does actually have to consent to the donation, and that gives them the legal authority to move that along. We also do a HIPAA authorization. HIPAA is the federal statute that prevents your health providers from disclosing your medical information or any other protected information willy-nilly.
Right.
So we do that HIPAA authorization to ensure that the people that you're appointing in those important roles are actually able to be educated,
Access.
right, and information and be spoken to. You would think it would be implied. It's not technically. Every time you go to the doctor, they always ask, to whom can we disclose this information? Right. And this is just more of a blanket one. It's not specific to Dr. Jones or Dr. Smith. It's anybody can talk to all of these people.
Great.
The fourth is the durable power of attorney. That is financial decision making, but I like to think of it as non-healthcare adult decision making. Right. Moving money between accounts, writing checks, paying bills, filing your taxes, requesting 1099s for your taxes, selling real estate, renting real estate, any of the sort of like adult things that you do to manage your life. If they're non-healthcare, they're covered by the other one. So when we're making those documents, we want to make sure that we are appointing people we really, really, really trust. If you do not trust that person to manage your finances and not take your money, that is not the person you should be appointing.
And those don't have to be the same,
They
right?
do not. They do not have to be the same. There's a clause in, I believe, the financial power of attorney that outlines how a conflict would be resolved. Right. Okay, so generally speaking, the healthcare agent gets to determine what treatment, and the financial just has to pay it. They don't get to veto it, and there may not be enough money for it, but we'd have to figure out how to manage it with your insurance, which they can also generally interface with through that document. Yeah. You also want to ideally have a backup named in both of those roles, because God forbid something happens to that person or they just can't take it on. Their life is overwhelming for other reasons. You don't want to be left without anyone named in those roles. And then generally for the durable power of attorney, the financial, I no longer recommend that people have two people serving in that role or co-agents. That was pretty typical a long time ago. Candidly, it's just become very difficult for banks. Banks are being difficult about accepting that. And that's not a knock on banks. They are trying to protect themselves, and they don't want a situation where one agent is acting without the consent of the other and they get stuck in the middle of that. So they're just making it more difficult for co-agents to serve. So if I'm trying to make it smooth, you've got two kids, I want 1, 2.
Got it.
Or 2, 1. But it doesn't matter which kid it is. We just want them sequentially in order, not together. Some folks feel concerned that your kid will be offended that you didn't name them in first or in anything. In 10 years of doing this type of work, I've seen that happen once. And then kind of with hindsight, they realize, oh, this is actually a pretty thankless job. And they're usually fine.
Yeah.
Yes.
So we have those 4 documents while you're still alive.
Yes.
And they're so important. And then you have this other one that you always put out here.
Yeah, your last will and testament has no effect while you're alive. It only has effect at your death. You can no longer use powers of attorney to manage the affairs of a deceased individual. Those all terminate at death. That is when your last will and testament takes in. And it frankly takes the place of all of those documents. It can deal with the disposition of your remains, which is sort of healthcare adjacent. And it very much deals with your financial affairs. Which would take the place of your power of attorney. So some folks will you can name the same person in all 3 of those roles. And in some ways that's nice because the person who is handling the financials under the power of attorney already knows the world of finances. They already know where you have a brokerage account and where you have a bank account. And so the handoff to the executor role is seamless. They already know where, the money is hidden.
That's right.
But you don't have to. And there can just be a handoff of authority.
I want to share an example, and I want you to think of some examples too, where a financial planner whom shared an example where a person died, a mother died, and her son was not listed as durable power of attorney and could not access any of her accounts, because people will say to us, you've heard this too, oh, but he's on my bank account. But those financial advisors couldn't access any of her investments or anything on his behalf. So that's a reason to have these
maybe
documents.
Possibly because if he was acting as power of attorney, that authority went away when she died. So he no longer had the right to access it. I always do also caution clients about when you have a power of attorney that's appointing, say, your son or whomever as your agent, and you're doing that with the purpose of allowing them to help manage your finances. You do not want that person added as a co-owner on the account. You want them added as POA or agent or however AIF, attorney in fact, whatever the financial institution labels it. Sometimes when folks take those documents into the bank teller says, "Oh, we're just going to add you as an owner. It's so much easier." Maybe it's easier on the back end for the bank. It is not what we want on our side of the equation. For a lot of reasons. For example, if your son, in this example, your agent, gets into a car accident and gets a judgment against them, that money is now available for payment of his creditors, when that money is really for the benefit of you and making sure you have the means, for the rest of your life. But also, to the extent that you have more than one child that you intend to receive assets at your death, you've now changed your estate plan. Now 100% of that bank account goes to Johnny, and it doesn't get split between Johnny, Julie, and James. And now Johnny would have to gift money to Julie and James in that situation. And that's just not generally what we want.
It's complicated. Well, that's just in the financial part, Koral. What would be the implications if someone did not have a living will, for example?
So living will, the classic scenario that we may all remember, although it has now been quite a long time, is the Terry Schiavo case. Where there was a legal battle about what did Terry want. Did she want to be kept alive by a machine? Did she want to be taken off of life support? And so the goal is that we're trying to avoid a conflict at a later stage, and we're trying to frankly carry out your wishes as to how you would like to die if you would not otherwise recover. Frankly, most of my clients, when I start talking about this document presumes you do not want to be kept alive by machine if you would otherwise pass. So this isn't dealing with, we're not trying to shove you off, right? You would otherwise die, but for the intervention of these medical devices, whatever they may be or that you may need. 100% of clients, oh my God, no, I don't want to be kept alive by machine if I would otherwise die. Now there may be I'd like you to keep me alive long enough that my children can fly in from California. That is an option under your document. They do not want to be 30 years on a respirator in a coma, not totally unaware. So it does not have to be that everyone says that, but everyone I have dealt with feels very strongly about that. So that's your implication if you don't have a living will, is you have the potential for a legal fight.
But what about the healthcare power of attorney? That's more common.
That one is more common in terms of needing something. So let's imagine a situation, and frankly, this applies also if you don't have the financial power of attorney. Let's imagine a situation where you don't have those things, and you have a traumatic brain injury, and you can no longer manage your affairs. You don't know up from down. You're incapacitated physically, but also you're unable to really carry out your adult affairs, your paying of bills. If you have a healthcare power of attorney, that person can step in to manage your healthcare decision making. If you have the financial power of attorney, that person can step in and pay your bills and interface with the hospital and sign all those forms. If you do not have that, the only recourse is, in North Carolina, we call it a guardianship. It's called conservatorship in other states. You can be a ward. There's different terminology, but the idea is a court-appointed person who is going to manage either your healthcare decision-making, your financial decision-making, or both. And if we're doing that, sometimes that's our only option, even when we have powers of attorney, which I can talk about in a sec. But if you don't have those documents, that is a public, it's a hearing, it's a court hearing. We're going to be subpoenaing medical records. There's going to be testimony taken as to your ability to do things. And it could result in the stripping of unnecessary rights, like the right to vote or to drive. If you could do those things, but maybe you just forgot, who the president is, but you remember how to drive home or whatever. It could result in the stripping of additional rights or liberties that we don't want. That being said, if we don't have a document and you cannot manage your affairs, it is our only option. But it is expensive, it is time consuming, and it's not the plan we would like to have if we could have an 8-page document or a 6-page document that covers this appointment.
Right.
So it's just, I mean, you roll the dice. Frankly, anyone who's over the age of 18 should be thinking about having, frankly, a will. Everyone needs a will, regardless of how much money or wealth or whatever you have. Everyone needs a will.
Or nothing at all.
Or nothing at all. But you also need powers of attorney because, if your kid goes to college and has a traumatic brain injury and you need to get a hold of them and find out what's happening at the hospital, if your kid is 18, you no longer have the legal authority for the doctors to communicate that to you.
And they won't. They won't.
And we've seen it happen where you have a 20-year-old who gets into a car accident and they're alive, but they're unable to manage their affairs. And if they'd had a power of attorney, maybe mom and dad could just step in, and instead we have to pursue a guardianship. Yeah. That's grim, and it's not things we like to think about. But almost 100% of my clients don't want to be kept alive by a machine, but also almost 100% of my clients come out of having prepared these estate planning documents feeling a sense of relief.
Yes.
Because you have taken this, it was scary on its own, but it's even scarier as an unknown.
Yes.
So they almost always feel better after they've met her. I try to make it as pleasant as possible.
She does. And others like Koral who do this every day, they really do try and make this pleasant, reasonable, and kind. And yet I say it over and over again, and I won't stop saying it. I think it's a gift you give to yourself and to your family when you put your wishes in writing. And even if you're 18 years old, honestly, I think it's a conversational gift you should have with your kids when they're graduating, because strange stuff happens, and this just protects all of you and make sure your wishes are known.
Almost all of my colleagues, when their children turned 18, they came in and signed documents that day, because we see, the downside when that doesn't happen.
Absolutely. Now, Koral, I see these two of these documents on the Secretary of State's website.
Yeah.
The two healthcare ones, the living will and the healthcare power of attorney. The durables in another place. Those are good documents. The Secretary of State has vetted them.
Yeah. So the living will and the healthcare power of attorney are actually statutory forms.
Yep.
They can be formatted differently by the attorney. Frankly, it's sort of, I always tell people, like, you're paying me for the work I'm doing on the will and potentially the financial power of attorney, and we're just knocking the other two in. That's not really I'm not making a living off of those documents, but I want them done because they need to be done.
Much.
The durable power of attorney, there is a pseudo statutory form, a short form and a long form, and we want to do the long form whenever we can because it provides more authorities.
Yeah. So those documents are out there, or you can seek the services of an estate planning attorney like Koral.
And there is also a document called 5 Wishes, which sort of encompasses the living will and the healthcare power of attorney, but goes beyond that. For some clients, it's a little too touchy-feely. For others, it's exactly what they want in terms of really outlining what is a meaningful life experience. And if I can no longer enjoy ice cream, if I can no longer enjoy the sound of children laughing, or it gives a lot more concrete guidance to your agents. But if you have a living will and a healthcare power of attorney, and then you subsequently sign 5 wishes, that supersedes everything. It encompasses all of them, but some clients also don't want to get into the touchy-feely.
And that's okay.
That being said, the more conversations you can have with your loved ones about, at a minimum, hey, the estate planning documents are in that bureau over there, to the extreme of, I want to be cremated, I want this song. Yes, it is grim, but I can tell you from experience, the children or loved ones who are left behind who've had that conversation with the person who passed are always so grateful for it. They're better situated to handle the experience and to really feel like they are carrying out that person's wishes than the ones who are like, I have heard many times, God, I wish mom had just told me once what she wanted. But mom thought it would make them uncomfortable, and it turns out it made them uncomfortable on the back end because now they're having to guess. I don't know. She never told me.
I know. These are such valuable documents, Koral. What should we leave the audience with today?
Everyone needs a will, and everyone needs a power of attorney.
I agree so wholeheartedly, and we're going to do this every year.
Yes,
over and over. It's that important, and we've seen the not pretty side of this. We've seen the very reasonable side of this, and that's a better place to be.
I tell people all the time, I see the best of people the worst of people and everything in the
Between.
middle.
And it's just better for all of you. So Coral, name the 4 documents again.
Yeah, you got your living will, also called an advance directive, your healthcare power of attorney, your HIPAA authorization, and a durable general power of attorney. And then your those are during life, and then your last will and testament after you're done.
It's that important.
Mm-hmm.
Awesome.
Mm-hmm. Yep.
Well, if you want to know more about how to get these documents for yourselves, you can go to the Van Winkle Law Firm's website, www.vwlawfirm.com, and Coral and quite a few of her associates would be happy to help you with that. Thank you.
And nothing we've said here constitutes attorney-client, the establishment of an attorney-client relationship. This is just general advice. You need to talk to your attorney.
Thanks for the disclaimer.
Yeah.
We almost forgot.
That's all right.
But it is important. And I'm just so grateful. Thank you for how you and your colleagues help us just inform the public. We want you to be aware of these things and make good decisions for yourselves. Yes. Awesome. Thank you, Coral.
Thank you, Maureen.
Well, join me next week, Monday, April the 27th, 2026. I'm going to actually kind of dig a little deeper into some of this and talk about the do not resuscitate order and the medical orders for scope of treatment.
Yeah, those aren't mine.
But I love talking about these documents at this time of year. It just brings it up fresh. It's that important to everybody. And so we'll look at those up. The goldenrod and the pink in North Carolina, but different colors in different states. So join us then. And if you have any questions about Four Seasons in the meantime, call us 866-466-9734, or please go to our website, which is fourseasonscare.org. Thank you. And have a wonderful Monday, everyone.
Yes.
Thanks. All right.